Toronto employment lawyer Stuart Rudner says employment contracts can shock both employers and employees. Well, Stuart, that's quite something. What do you mean by that?
Well, employment contracts and termination clauses in particular can be very useful, but they can also cause a lot of stress and surprise. For employees, it usually happens when they're let go, and they find out that instead of getting a massive severance package, as all of their friends seem to have received, they're getting a package that's a matter of weeks. And when they ask why, they're told that when they started employment, they signed a contract, and that contract had a clause which limited them to minimal notice of dismissal, which of course they didn't really pay attention to when they signed because they were just happy to have a new job. The flip side of that is for employers who may have done the strategic thing and asked their new hire to sign an employment contract and it had a termination clause, and they assumed that they were protected. So they proceeded with a dismissal, assuming the employee was entitled to minimal notice, and they're shocked when they get the demand letter from the employee's lawyer saying that the contract, and the clause in particular, are not enforceable, and the employee is entitled to far more notice than the contract says.
Well, why would the contract not be enforceable?
Great question, and this is something that we spent a lot of time on over the last few years. There have been many cases before the courts, in particular in Ontario, the last couple of years, where courts are being called upon to decide whether contracts and termination clauses in particular are enforceable. And there's two ways to attack them. One is to attack the contract generally. Easiest way, because the way that most employers don't get it right, is they don't have the employee sign when they make the offer. What employers typically do is they make an offer of employment, the employee agrees, they set a start date, the employee shows up for the first day, and then they ask them to sign the contract. At that point, it's too late. They've already got a verbal agreement, and the law of contract requires that there be consideration flowing both ways in order to have a binding contract. So if you've already given them the job, you have to give them something new in order to create a binding agreement. So that's one way that employers mess it up. And as a lawyer that is often consulted by individuals who want to know whether they are really stuck with this contract they signed, the first thing I check are the dates. What date did you sign and what date did you start work? And if they're the same, then 9 times out of 10, the contract is not enforceable. The other way to attack it is the clause itself. Taking a step back for a second, what you have to realize is that the default in law in Canada is that if you're going to be let go without cause, you are entitled to reasonable notice of termination. And there are no easy rules or calculations for how you assess that, but it takes into account your length of service, your age, the nature of your employment, and it can often be 2, 3, 4 weeks per year, and in rare cases it can be 18, 24 months. That's the default. What our courts have said is you can contract out of that, but the contract and the clause have to be absolutely clear and unambiguous. And if there is any ambiguity, or if you breach the employment standards minimum, it's out. And most of the cases we're seeing now are trying to figure out whether a particular clause is clear, unambiguous, and is consistent with the employment standards legislation.
Is there a quick suggestion?
Well, the easiest suggestion is work with an employment lawyer. We have corporate clients, and I have clients I've worked with for years. We have an ongoing relationship. We've drafted templates for their contracts, and every time they're going to hire someone, they use the template, they fill in the details, they get us to have a look. What we're looking for really is to make sure, first of all, that the details of this hire are as they should be, but also that nothing has changed. The laws evolve, best practices evolve, so we can tell them that the contract they're using, which might have been appropriate 2 years ago, is now not the best practice. So work with an employment lawyer, and for employees, I mean, the most important thing is never sign anything until you have it reviewed by an employment lawyer. You know, it's very easy to say, I'm just happy to have a job and I'm sure they're going to treat me fairly. But if you sign off on a contract which limits your employment notice of dismissal to employment standards and minimums, you could be in a situation where 20 years down the road, you're let go, and instead of getting 18 or 20 months of severance, you might get 8 weeks.
Important information. Thank you very much.
Thank you.